Holly, we were talking before Mark called about more and more people are passing away with a living trust. And
Yes.
in a living trust, you always name who's going to be the successor trustee. And that is the person that will often call us and get advice about, okay, my dad died with a living trust. He named me the successor trustee. What do I do now?
Right. What are my next steps? What do I have to do?
And the Florida statutes lays out some very clear steps that they are obligated to do. And I would say first and foremost, it says that if you want to be this, if you've been nominated the successor trustee and you want to be the successor trustee, the very first thing you need to do is to accept that job in writing.
Absolutely. Yes.
And here at the Olsen Law Group, we can prepare that form for you, acceptance of successor trustee. It's very important.
It is.
And then the next important step that we do is to notify the beneficiaries. We give them copies, and what do we send them copies of, Holly?
So they'll get a copy of the living revocable trust. If there were amendments to that trust, they'd also get copies of that. And then we typically are asking that they sign a receipt that they've received those copies, along with a copy of the letter where the trustee, the successor trustee, has accepted that position.
And then we also send them a limitation notice. And Holly, tell the listeners about that.
So that limitation notice is very important because it spells out what the beneficiary's time frame is for filing a contest to the trust itself, because there's a certain amount of time that you have to make that contest known, and if you are outside of it, you are limited.
Exactly. So that if a beneficiary were to receive a copy of the trust and they would say, wait a minute, that's not mom's signature, or mom was incompetent when she signed it, or any other objections to it, this limitation notice tells that beneficiary that you've got 6 months from the time that you receive this letter where we send you copies of this stuff to object to that trust or that amendment that we did. And after that, you're forever barred. It is what it is, written in stone.
Absolutely.
So, Holly, when we do a trust administration for clients, of course, the successor trustee is our client. That's the one we're
Right.
representing. But there are many beneficiaries. But the beneficiaries, they are not in the dark about what's going on. They know what's going on. We send them updates as to what's going on with the trust administration as we move along.
We do, because communication is absolutely an important factor when doing trust administration, keeping the beneficiaries up to date with the steps in the process.
And one of the first things we send them would be an inventory of the estate assets. Tell the listeners about the inventory.
So the inventory would describe what assets and or property the trust owned at the time of the passing of the original trustee, and lays out what needs to be processed and what will get distributed once everything is accounted for.
So when the beneficiary gets a copy of the trust, they can very quickly figure out, okay, this is what I'm entitled to, whether it's a percentage or the estate or a dollar amount. So from the get-go, they know what they're going to get.
Yes.
Then, and let's say most of them are in for a percentage.
Usually.
Then they get the inventory. They can say, okay, this estate has got $1 million in it. I'm in for 10%. I should expect a check for $100,000. Everything's good so far. And then at the end of this trust administration, there's a lot of steps. We're just kind of jumping ahead to the end. We do what we call a petition for discharge. And tell the listeners about that.
So that would be an actual document filed to ask for the discharge or the final accounting, as it will, of the trust, and that all beneficiaries have been paid out. All assets and property of the trust are distributed from the trust, and we can now close that administration.
Yeah, within that petition for discharge, again, we send it to all the beneficiaries per Florida law. It lays out how the successor trustee intends to divide the estate, what the attorney's fee are, what the trustee's fees are. And so now the beneficiary has gotten this. And so now after we start off with $1 million, but by the time we pay attorney's fees or successor trustees' fees or creditors, doctors, hospitals, credit cards, let's just use some round numbers and say there's $900,000 left. Well, now the beneficiary can say, oh, I'm in for 10%. Now my share is $90,000.
Right.
Now, when we send that petition for discharge to the beneficiary, now we send another limitation notice and tell listeners about that.
So that would be dictating and explaining the amount of time you have to challenge the amount of money that possibly you're receiving, the maybe you don't agree with the amount of attorney's fees or the trustee compensation, or you're thinking that certain bills are being paid that shouldn't be paid by the trust, but this is your time in which to make those objections. Yes, thank you.
Very good. All right. Well, great job, Holly. Thanks so much. Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law.